Not getting no, it's actually Monday. Yeah, no. And Justice Rose is on. Oh, I think he's right back there. Oh, right back there. Oh, I guess I haven't met him. Okay, well, he's a business teacher. Okay, well, I need to meet him then.
I want to make sure it's always perfect.
Sandy, blue shirt. That's why I wanted to make sure that I was getting it right. Okay.
Hi, how are you, Jeffrey?
I'm doing.
Good. Hi, Aaron. How are you? Nice to see you. Good water.
I'll call you back there. Here you go.
Are you one of my handlers? I need lots of them.
I probably, you know.
Fellas, how are you?
Yeah, that's 30 is a nice drive.
It is, it's pretty. So I live there on the other side of Riesel and Perry.
Oh,
So
okay.
it wasn't nearly as long,
Mhm.
but it was
Oh,
still
it
pretty.
cuts off about 20.
Top 10 America speed tracks.
Yep, Riesel.
Yeah, someday I'll tell you my recent story. It's hilarious.
There,
But
Officer Dietrich back in 2009, 2010, driving without insurance, he would pull the people out and tow their cars.
oh, you're kidding.
No.
Oh, my word.
Yeah.
Oh, my goodness.
Yep.
Oh,
Not no more, but
is that legal?
I don't know, he did it. So I mean, whenever no one's around, I think everything's legal.
I mean, I agree with the idea, but maybe not the action.
Yeah. I don't know.
The law, you're supposed to have insurance.
Yeah,
So,
yeah, that's why they get tickets.
yes, exactly.
Well,
Yeah, yeah.
Yeah.
Did a big help on getting all this right.
Yeah. Yeah. That, at least for me anyways, I don't know the logistics, I'm not part of that. But he helped me out.
We got the email from students, you know, she sent to me, haven't had a chance to, you know, see what the
Yeah, right.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Gentleman who makes my cop, you have to push the button. Want to welcome everyone to the oral argument session of the 10th Court of Appeals being held in Bryan, Texas, on the 6th day of November 2024. Glad to have y'all here. I make that announcement that it is in Bryan for a very specific reason. The Constitution of the state of Texas only allows us to sit in the county seat of each of the counties that are in our district. There are 18 counties in the 10th Court of Appeals district, and Bryan is the county seat of Brazos County. The interesting thing about that is that there is y'all may have heard of it, another university in this adjacent town over here called College Station. We cannot go sit in College Station, so the Blinn campus, the Blinn College, has something that A&M does not. So that's a point of pride for y'all. It is good to be here. It's good to be with you all. If you're anticipating a full day of 3 cases, I will give you a bit of discouraging news. The second case, which was a state's appeal, which is an unusual event when the state gets to appeal a criminal case, will not be heard today at 11 o'clock. The state's attorney was ill, had a family illness that came up unexpectedly, of course, and so we granted a continuance late yesterday afternoon in that case. And so we will have one today at 10 o'clock. We will have a Q&A session that will begin when probably somewhere around 11 o'clock, the time that case was scheduled to begin. And then we're actually going to try to kind of regather at noon, because there's another class that was going to have be here for the Q&A session that was scheduled at 12 after the second case that's now canceled. Then we will have a case this afternoon at 1:30. We did try to pick cases that we thought had some application to students, in particular cases in which there may be a student and a police officer contact or involvement. And so I am apologetic for not being able to present all 3 cases, because it made a really nice trilogy of issues, and you'll just have to follow that third case on your own. Speaking of which, in the chair when you sat down would have been a pamphlet. In the pamphlet, there is an explanation of how to log on to the court's what we call case mail. You would want to do that to follow what happens in these cases, which causes me to bring up another point. If you were expecting live witnesses with a Perry Mason moment where there's a confession of error or wrongdoing by one party or the other, you're going to be disappointed today. There are no witnesses, there are no court reporters. And in fact, there's 3 judges instead of just 1. So, it's a little different. This is an appellate court. The cases have already had an appealable decision made in a trial court, and that's why they are here for appellate review. Once we hear the arguments of counsel, well, let me explain what's already happened in these cases. They have reached the point where there is an appealable order. The parties have filed a notice of appeal and briefed the law as related to the facts of their case. So we have a lot of paperwork and knowledge already about these cases. Those briefs have been on file for several months, and so we've studied them. We're familiar with those, and today the attorneys will make their arguments to us. After today, we will go back to Waco. Jeff will actually go back to Austin, but that's another story. But we'll go back to Waco, and the staff attorneys that work for each of the judges will work on this case and work up a draft opinion. We'll circulate it, vote on it, and then it will ultimately be issued. If there are any public filings during that time period, that is what will pop up on case mail. You'll get an email notice that something has happened in the case that you're following. The most likely next thing that you will see in these cases will be some type of supplemental briefing on the case. Then you can go in and read the briefs, you can go in and read the supplemental briefs, but then at some point you'll get an email and there will actually be an opinion that has been issued in the case, and that's what you're waiting for. That's the court's ruling on the case. Now, what is a little bit different about today than other cases that are argued at the court is that we allow the attorneys to actually come to the lectern and turn and talk to you all for 3 minutes. The point of that conversation with you is to put this case in context, either the facts or the procedure, something that they think is important to let you know about this case so that you can understand the arguments that they then turn and make to us. We would not normally do that in our courtroom in Waco. We do that because we are on the road. This is an educational opportunity, and we want you all to get the full benefit of that. One other thing that is a little different today than normal is that normally we don't have any photography allowed in the courtroom while we are preparing for the case or presenting the case. And if you notice, Robert's back here and he's taking just photo after photo. And that's okay. In this context, we allow that, that's permitted. The other thing that is something that started as part of the pandemic that we have elected to continue is that used to, we did not video record anything that went on in the courtroom. It was not publicly available. You had to come to the courtroom to see it. This device that you see sitting in front of me that's called an owl, it is projecting a 360-degree image of everything that goes on here, and as well as the sound sensitive microphones directs the camera to who is speaking so that it can be recorded, and it is being live streamed on the court's YouTube channel, and the address for that channel is also in the pamphlet that was provided. Okay, that's all about the administration. Now I want to say some thank yous. We've been doing this for any number of years, and I really don't remember how many. I'm sure Robert probably remembers when we started as 12, 14 years ago. It's been a long time. We've been here many times. We've had tremendous, and I do mean tremendous support for this program and doing this as part of Robert's Lasso program that from literally the top of the administration down. She has had many titles while I have known her, while she's been in various roles from president to dean, chancellor. I personally, my favorite for her is queen of the campus, Mary Hennessy. And she is not with us today. She had a commitment that she could not avoid. And I know personally from conversations with her that She normally puts this on her calendar with a do not change block on her calendar, but there was something that she just could not avoid today. In addition to, her support, we've got a lot of support here on the Blinn campus. Executive Dean, of the Rellis campus, Chris Mars, kind of looks after us, provides the facility and make sure that, the other folks, I guess you would say, do their job. Eric Graham, has done our, IT, made sure that I was able to get on the internet and do the live stream. We have Dean of Social Sciences with us today, Brandon Franke. I always mispronounce his name, but he told me today, a really good pseudonym is just, it's Donkey with an F. And so, I appreciated that. And then Haley Mitchell, Holly Mitchell. Holly, it's something there, not Holly. Haley as in Barry. Mitchell is the, coordinator of student leadership and activity. Legal counsel, Lisa Schubert. Lisa, I don't think I've met you. Lisa, good to see you. And, then we have some students and officers of the LASSO organization. There's too many to list, and give specific titles. I'm just gonna call out their names: Colby, Grace, Emma, Sarah, Tara, Tamara, Matthew, Byron, Joshua, Joe, Jason, Brian, and Richard. If you're in the audience, please stand, because this is our host. This is the people that make sure we get to where we are supposed to be. Now, I know I stand. I want to make sure that, at least the camera records your presence. Thank you very much. You may have a seat. The technology has changed over the years. When I started doing this, I had to caution everybody about their pagers. Now y'all don't even know what pagers are, but be sure your cell phones are to the off or silent position. And I gave more announcements than I was going to. I thought we were going to be one press for time, but there's another reason you'll see in a minute. But let me introduce the bench. To my right is Jeff Rose. Jeff Rose is not an elected member of the court, but he is here today to serve as a justice on the first case. Jeff Rose has retired from the Austin Court of Appeals. He was Chief Justice on that court until several years ago, and is now a mediator and visiting judge. And we're glad to have you today, Jeff.
Chief, if I could make one comment, we've done similar things like this at one of the law schools that will remain nameless there in Austin. And I think we had 2 students, so I'm really impressed with the turnout among the students this morning. Glad to see you.
Thank you, Jeff. And to my left is Steve Smith. Justice Smith has been on the court almost 4 years now, and good to have you. He was a trial judge here in Brazos County for a number of years before that, and so he will be is also on the first case. And the first case is Weaver versus State, and we would like announcements from the counsel on the case. Unfortunately, I have to say that we only have one of those counsel here. And so, Mr. Lefman, we would like your announcement, and if there is anything preliminary that we need to take up before we start arguments.
Kevin Lessman for Mr. Weaver, Judge. I'm ready. There's no preliminary matters other than the state getting here.
Okay.
He's on his way.
He's on his way, and do we have a ETA? Okay. Do we know if he rolled into the 10th Court of Appeals in Waco at 10 o'clock, and so he won't be here until like noon?
That is not the situation.
Okay, all right. So we might send out the lasso groups to see if we can lasso him in the parking lot. Actually, there might be literally, if we had somebody that was front and back looking for a lawyer that's trotting in, it may expedite him getting here. Otherwise, we have a choice. Gentlemen, do you want to proceed with arguments, or you want to give him a few minutes to get here?
I'll defer to you, Chief.
I'll defer to you too.
We'll give him at least 5 minutes. So somebody put a clock on it. Oh, look, I have one right here.
quacks.
Probably shouldn't use a quacking timer. This would be a good opportunity if you had a question, to ask and, Kevin is the one that's under the most stress right now, because Kevin is, sitting here waiting to argue his client's case, his client's appeal. And so for that, I apologize for the delay, but, it would be a good time if somebody had a question, generic, to bring up. Be a great time, really? Really? Okay. I'm stunned. No one asked questions. Steve, is there anything that you would like to say to the assembled mass?
Well, as someone who lives down the road a couple of miles, I can't figure out why you don't have any questions. Really?
There's always something going on in Bryan College Station, isn't
Well, there is.
there? And the law.
And the law. We, here in Brazos County, we have 4 district courts, 2 county courts of law, and they make up part of our business. Actually, we cover 18 counties, go all the way to Waxahachie and Cleburne, if you know Texas. That sits just south of Dallas and Fort Worth. And we've been a part of this court. This court's what, 101 years? Are we 101 years old this year, I believe?
Something like that.
Yeah. And in that time, I'm the second judge from Brazos County. And we're the second largest county by far. And so it's been a privilege to be on the court with Judge Gray and Judge Johnson, who will be sitting on the other case. Just so you'll know, this case that we're hearing first comes out of the court where he sat in Waco. And he chose, as I have done before in cases where cases have come out of my court, to recuse ourselves, to avoid any kind of appearance of impropriety. Whether or not we really did much on the case or not, if I so much as signed a bond, setting a bond for someone, I want the parties to know that I'm going to step away and let eyes that never put eyes on the file as a trial judge make the call on the appeal. And so that's why Matt will be joining us later on. We've been here before when I think I was recused on a case last time we were here. And so it's just something that we do to try to make sure that we have the confidence of the people whom we serve. We want people to know, you read a lot of stuff today. And I can tell you that Chief Justice Gray, Justice Johnson, Justice Rowe, and myself, we do our best to make the calls based on the law, based on the facts. And we don't let our personal opinions get in the way. That may not have been what you wanted me to say, but that's what I said.
Very good summary, of what it is we do.
Lane has a question.
Lane, yes.
Just for our information, for the people who may be listening, out of the 18 counties that make up the 10th district in a typical year, on both civil and criminal cases, how many cases do you get up that are appealed, and how many do you dispose, if you know, on the criminal and civil side?
I'd have to do quick math, and that's not my forte, but historically, when I first came to the court, we were having close to 500 filings per year. We are now down, and the ratio of that 500 was about 60% civil and 40% criminal. And so what's that? 200 criminal, 300 civil. And out of that 500, we would transfer to other courts of appeals under an equalization protocol, where we try to equalize the workload across what was then 80 intermediate appellate court judges, to equalize that workload, about 100 cases to other courts of appeals. As different things have impacted the number of filings. We are now down to about 400 cases per year. And statewide, the percentage decline is even greater than that. So we are still the highest filed per judge court in the state of Texas for the intermediate appellate courts. What that means is that when you do this equalization and we're down to about 400 cases a year now, Lane. What is interesting to me, having studied this over a couple of decades, is that that percentage has now changed such that we now have about 60% of our cases are criminal cases and only 40% of those cases are civil cases. So it has really changed the nature of the cases that we hear.
Is that because of the Blinn kids?
Yeah, you know, I can't say that it is. They are not significantly impacting our criminal.
Yeah.
It's, if you had to search for a single fact that you could actually do an electronic search for, if you searched Northgate, you could find a lot of cases that impact our docket. But other than that,
And possibly do a search for Dixie chicken.
but we still wind up transferring out about 100 cases a year. It's not quite 100 now, it's about 90. But that is still the nature of the number of filings that we have that exceed the statewide average. So our relative position to the other 14 courts of appeal, that 13 actually, I could talk about 15, but I'm not. The other 13 courts of appeals across Texas that do what we do, we still have by far the most filings per judge, even with the decline in statewide filings. But
and it could be that the decline in statewide filings has something to do with COVID. I think
we experienced very little decline in our filings during COVID proper. In the post-COVID, surprisingly, the second year is where we saw a bit of a decline, but the bigger effect we saw was a result of the legislature. It's been almost 10 years ago now, and I'm trying to remember what year it was, but in the second major tort reform bill, they did a lot of, I'll say, tweaking of the medical malpractice field. And so the tort civil cases where patients were suing doctors and other healthcare related fields, that was where the statewide filings were really impacted. The areas like Austin, Houston, Dallas, all of those saw significant declines at that time in the number of appeals that they were receiving. But also during COVID, obviously, we didn't see as many appeals, but it had much less impact than I would have thought looking at the numbers. So that decline, it definitely is partially attributable to COVID, but more so related to, I think, tort reform. Jeff, you want to comment on anything that Steve had to say? And
well, I know when I visit with folks your age, a lot of times and new lawyers, one of the questions you always get is, how does a person become a judge? I have people walk up to me that are 20 years old and say, oh, I want to be a judge. And I'm like, well, I had no idea I wanted to be a judge until I actually fell into being a judge. And I thought you guys might talk about your path. I mean, I was a civil lawyer in a big firm and ended up going to work for the Attorney General for a brief shining moment, and just had the opportunity as a Republican in Austin. I didn't think I'd have to do it for very long. Turned out to go on the Court of Appeals and did it for about 13 years. So it's an interesting path. I think every judge has a different path to get there. But for the most part, keep in mind that none of us went to school and majored in judging. We all were lawyers of some sort, either prosecutors, defense lawyers, lawyers in law firms and represented people. And so it's good that you get a mix on the bench of different personalities, different backgrounds to decide these cases. And one of the things when a case comes up on appeal, you get 3 judges because we're having to take a look at what happened below. And so a decision that a single judge made is sort of a safety net, the appellate process, that you get another look at it. And so that's the reason there's 3 of us here. We'll collaborate, coordinate, decide what the right answer is, and go on forward. So that kind of gives the judicial system a little bit of a backstop. And then the one other thing I've mentioned, just given that yesterday's election day, is, most judges in Texas, and all of us have to stand for election and partisan elections. And I know when you drive down the road, you see, all these signs with judges' names on them and things. And frankly, I think I'm probably in the majority of judges to say that that's really the most unpleasant aspect of the job, is having to run as a political person, because none of us really set out to be politicians. Most of us got into this because we really love the law and want to make fair decisions and put politics aside. And so it's kind of an ironic system that we have. So I'm really enjoying, yesterday was the first election day in quite a while that I didn't have to worry about losing my job the next day. So that's always kind of nice.
You want to talk about your path? And by the way, I got a message, not from the lawyer that was doing the arguments, but from his boss, the district attorney in McLennan County, that he took a wrong turn, that he is close, so. Now, if
He
you,
obviously hasn't heard that Highway 6 runs both ways. But I came to practice law here in Bryan College Station in 1977 and was engaged in private practice in a spot on the College Station Municipal Court came open for an associate judge, and I had some individuals tell me that they thought I might do a good job in doing that for very part-time. So I did that, later became the presiding judge there. If you're ever in the College Station Municipal Court, be sure and look my picture up. We call it the Wall of Shame, all the former judges. You may not recognize me, I was probably 50 pounds heavier at that time. Then we had a county court of law race that came open, and I was elected to a 4-year term in county court of law. One of our district judges in 1998 decided to retire. I announced for the job, and remarkably, I didn't get an opponent from either party. And so I began a career as a district judge in the 361st District Court, beginning January 1st, 1999, the same day that Justice Gray was sworn in as a justice on the 10th Court of Appeals. And I served there until September 1st of 2021, when I was appointed by the governor to replace a vacancy on this court. I was the only second judge from Brazos County in 100 years. As I told you, we're the largest county other than McLennan by far. And so I've served here since then, and it's been a really interesting experience. Being a trial judge and being an appellate judge are really 2 different animals. And I've been able to learn a lot, I hope. And also to bring a little bit of benefit from the perspective of having been a trial judge. That's how I got there.
yes, question in the back.
Thank you for being here. We really appreciate it. I'm Dr. Abel Kincaid. I'm Dean of Humanities. And for our students who are present today, I wanted to ask in terms of academic path. So there are 2 primary roles in my understanding. There is the job in the courtroom, and where it is face-to-face and you're speaking. So I would be interested to know what helped prepare you, other than obviously understanding the law, but in terms of speaking in a public forum and having to be so thoughtful about and careful with what you say and how you say it. Then I understand the decision, the written word then dominates. So I'm curious in terms of academic preparation, what helped you the most in satisfying those 2 aspects of the job that you do?
Either one of y'all want to take that first? I'll be happy to if you don't.
You seem to have an idea.
Go ahead.
I'm gonna comment actually on Steve's background first, and why I think.
Do I get a rebuttal?
You do.
Okay.
Why I think that's important. He has an undergraduate degree in music and anticipated being a music instructor. for his career. And, I tell people, choose a challenging degree field and something that makes you think, makes you challenge, make you organize. And actually, music does that. You have to think about not just what note you're playing, but what notes are coming up and what is the measure and all the things that musicians have to do, which I know absolutely nothing about. But it was a challenging academic field that taught, I would say, precision and organization and planning. My background at the undergraduate level was accounting, and then I got an MBA from A&M and practiced public accounting for 3 years. It provided a lot of the same type training elements, if you will, organization, deep attention to details, things that were academically challenging. But in answer to sort of your first part of that question, what provided me the ability to communicate? I actually did that from high school, working for the telephone company in Conroe, Texas, where I had to meet the public on a day in, day out basis and explain to them what I was about to do to their home to be able to install a telephone. I saw a young lady last night at one of y'all's establishments, Gringos. She was working the front counter, the hostess station. And I thought, what a challenging position that she's in. She has to meet every customer that comes in the store, make sure that they're somewhat satisfied, get them positioned, show them a table. And I found out that she was a junior in high school taking 4 AP classes. Last footnote on that aspect of it, my daughter once did a similar hosting position at a restaurant, and she said every person should have to serve in an industry where people are separated from their money at some point in their early career. It will teach them what they need to know about engaging with the public. So that's the public engagement part. The other part to your question, which is very appropriate, what's the academic aspect? Anything that teaches writing, English, you have to, I noticed that you were Dean of Humanities, so it's probably a self-serving question. That is fundamental to the way that we communicate in the law, and it is even more so today than it was 20 years ago. 20 years ago, 30 years ago, 50 years ago, the advocacy from the lectern was the be-all of being a lawyer. That's what you thought of when you thought of the law. You thought of these oratory skills that lawyers had. That is such a small part. To kind of put a footnote on Lane's question earlier about the cases that we hear, a very small number of cases that we have filed in our court actually make it to this level where there's oral argument. It is almost all done in writing, and the ability to communicate is quintessential to what we do in that regard. You have to be an advocate in that writing, but you have to be precise. You have to write with regard to both your client's facts as well as the law. It's very challenging to be able to do that. I've seen some people, lawyers that are great at it, and I've seen other lawyers that have tremendous skills at the lectern that can argue a case that really can't complete a sentence. And so they have to find someone else to do that for them.
I guess the only other thing I would add would be my plug for the practice of law as a potential career, because certainly, you're not going to get to the judgeship right off the bat. Really, your initial decision is, do I have any interest in practicing law? And I know in our society, we like to joke about, gosh, lawyers, lawyer jokes, this, that, and the other. First thing we do is kill all the lawyers, as Shakespeare said. Well, that's because they were the obstacle to them taking over and overthrowing the government. And so, there's a lot of value to practicing law. And I was an accounting and economics major. Wasn't for sure I wanted to go to law school, but knew that I had an interest. But the thing about practicing law, and you kind of talked about the writing aspect and the speaking aspect. In the practice of law, we sometimes say that you have sit-down lawyers and stand-up lawyers. And, the sit-down lawyers are people that do transactions and advise companies that are behind the scene and on the front end, kind of structuring how things are going to happen so that you can protect yourself, protect your client. Whereas the stand-up lawyers are the ones that have to come in after that goes awry, or people get in fights later that actually participate in court. But there's just so many things you can do with a law degree that I never would discourage anybody from practicing law. So I think it can always be applied whether you actually practice law, whether you go into business. Almost everything we do these days is governed by relationships, and those relationships are more and more complex. And so the ability to understand contracts, identify potential problems and that type of thing can be a really valuable, whether you're in business or whether you actually go into law. And then once you're in law, whether you're a sit-down lawyer and advise companies and structure things, or whether you're a stand-up lawyer and try to fight it out in court. So I would always try to counter the wave sometime. And a lot of times even lawyers are like, oh gosh, I would never advise anybody to be a lawyer. But I've found great joy in being a lawyer. I've done it in a whole lot of different contexts, and really enjoy. One of the things I like about being a judge, or when I was a judge and now that I'm a mediator, is you get to see all different sides of different businesses. And so I admit that I'm about 6 miles wide and about 2 inches deep on a lot of things, but it's really interesting to get to learn about all those things and look at it from a perspective that sometimes even the people that own the business or are involved in it don't look at it, because you're having to figure out how to protect them in their interactions with other people. So it's just really a rewarding and versatile degree path if that's something that you want to do. And to get there, as the chief said, it can be anything. It can be music, it can be art, it can be history, it can be humanities. I'm going to hit the humanities since that seemed to be the answer that will get us the most credit today.
Everything you said about writing English is important. I might add just a couple of things. Maybe, and do this as electives, no matter what you are, a couple of history courses, at least, to learn a little bit about the history, especially of our government. And number two, take one accounting course. Because you never know when you get to be a lawyer, and all of a sudden you are now the named partner in a law firm. You need to know how to read a balance sheet and a financial statement. And you need to know what they do. So take at least one accounting course as one of your electives.
Okay, I have no update on where our attorney is for the state, but we're gonna go ahead and start the first case. And unless somebody else has a burning question that you're not going to get to ask in an hour because you've got to leave. And I'm sorry that we did not get started on time, but we tried to go with the facts as they are presented. So at this point, I'm gonna hand it over to Kevin Lessman. He is the appellant representing Mr. Weaver in the appeal of Weaver versus State, cause number 10-23-00347 CR. And counsel, as soon as I get this over to 3 minutes, you may proceed when ready.
You know, hear me. Can you start your timer?
Just, it started, I'll give you a 1 minute warning, but if I see you're about to wrap up, I'll let you wrap up.
Ladies and gentlemen, thank you all for being here today. My name is Kevin Lessman. I'm Mr. Weaver's appellate attorney. Quaylon Weaver is the appellant in this matter. A little brief procedural history. Mr. Weaver was indicted and convicted for evading arrest or detention. He had a jury trial. At the jury trial, he took the stand, he testified, he confessed to evading. He also provided reasoning on why he evaded. He requested a jury charge instruction for the defense or justification of necessity. The trial court essentially denied his request, and Mr. Weaver was convicted to 40 years in prison. Factual summary. First off, Mr. Weaver back in 2016 was a victim of a horrendous police brutality act. This case transpired November 13th of 2019 at a 7-Eleven in Waco, Texas, approximately 11:30 p.m. Mr. Weaver's inside of the gas station. He is checking in, checking out. Officer Christopher Merrick comes in. Mr. Weaver and Officer Merrick make eye contact. Mr. Weaver leaves the gas station. He goes to the fuel pump, pumps gas into his car. This takes approximately 5 to 10 minutes. During that 5 to 10 minutes, Officer Merrick is inside of the gas station. He leaves the gas station, goes to his car, gets into his car, starts the ignition, and just waits. Whenever Mr. Weaver is done pumping fuel into his vehicle, Officer Merrick proceeds to pull up behind his car while still at the fuel pump, runs his license plates. The return comes back unconfirmed insurance. Mr. Weaver sits in his car for approximately 3 to 4 minutes. He calls his significant other, Miss Angela Jackson. Afterwards, Mr. Weaver leaves the gas station and Officer Merrick pulls him over for the unconfirmed insurance. The stop happens at Richland Mall parking lot in Waco, Texas, a dark area. It's about midnight. Whenever Officer Merrick does his initial approach, it's cold outside, it's late, he's trying to put on his jacket, there's a delay, there's a good minute delay. Mr. Weaver is panicking and he's talking to Miss Jackson on the phone. Eventually, Mr. Weaver takes off and he evades. Testimony during court is Mr. Weaver evades and is speeding through residential neighborhoods going about 80 to 90 miles per hour. Mr. Weaver provided his reasoning on why he evaded is because, one, he felt as if Officer Merrick was stalking him at the gas station. 2, due to his previous police brutality acts that he was a victim of. 3, it's late, it's dark outside, no one's around. That's the general summary of this case, both procedurally. Our argument is, or the reason why we're here is the trial court denied him a jury instruction for justifying his evasion. That's it. Thank you.
Thank you, counsel. I got the thumbs up. Did that mean he was here?
As far as I know, he was in the
Parking lot?
parking lot.
Okay. Counsel, I'm gonna ask you to go ahead and start and, state will have to respond without having heard some of your argument.
Sounds good, Jim.
You may proceed when ready. You might pull it up a little so that, yes, perfect, thank you.
So, Mr. Weaver took a stand, he confessed. He asked for a justification, necessity justification. Necessity justification is a void and a confess and void justification. Mr. Weaver did take a stand, he confessed to evading, he provided his reasoning on he was victim, late at night, so forth and on. There was also another defense witness, Miss Angela Jackson, who was his significant other at the time. She was on the phone during the entire criminal episode. Miss Jackson takes the stand and she testifies to the same thing. Mr. Weaver, during trial, requested a jury charge instruction or necessity instruction.
Counsel, was there a discussion about the charge prior to a formal charge conference, about like at the beginning of trial, or when did the conversation about the justification defense first come up and the charge in particular?
If I recall correctly, Judge, it was before whenever the jury charge conference is happening, not before voir dire, during voir dire.
So there, as far as you're familiar with the record, there wasn't any pre-trial, or pre-closing, discussion of what the, charge is gonna look like?
Not that I can recall, Judge.
Okay.
So before closing arguments, there was a request from defense trial counsel. Defense trial counsel on the record made his request, made his reasoning for the request. There's two witnesses that took the stand, testified, provided justification. And so just that under Article 36.14 and 15, since it's a special, the trial court should have granted him his request for the jury charge instruction. Whenever there's any evidence whatsoever, presented at trial court, the trial judge has a duty. The statute says shall, not at its discretion or anything like that. The state provided argument saying that it's unreasonable, et cetera, et cetera. Reasonableness is a question for the jury. Essentially, whenever the trial court denied Mr. Weaver his request, the trial judge usurped the jury's position as the trier of fact and determined essentially that Mr. Weaver was not entitled to that, was not entitled to have a juror of his peers determine whether his action of evading was reasonable or not.
Well, one of the elements, as I recall, of the necessity, justification defense is it has to be a reasonable belief.
Correct.
And some of the case authority has held, come ahead, starting to have a council table over. Some of the cases have discussed the lack of need to give the instruction if the purported justification is unreasonable. How would you address that argument from the state?
I would address it that evading arrest is a continuous offense. So at the beginning of his evade, he's in a dark parking lot, the Richland Mall parking. In the Richland Mall parking lot, there's a delay between the officer and his initial approach. I'm 30 years old. I've gone and I've pumped gas at many gas stations. I have never had a cop pull up behind me and just wait while I'm pumping gas. That right there, along with the other testimony that he provided, should have provided him that instruction. Now, later on, going 80, 90 miles per hour for residential, that can be what you're talking about. Yes, as a matter of law, is it reasonable or not? But it's a continuum, it's a spectrum, this offense. So at the beginning, yes, it's reasonable. He should have been given it. Does that answer your question?
I think so. And if I understand your argument, it is about the error in the refusal to give the instruction, and you're not relying so much on a harm analysis at this stage.
So standard of reviews twofold. One, two-pronged. One, is there an error in the jury charge? If so, was there harm? Per the state's principal brief on page 17, if y'all have it in front of y'all, they're quoting Roger v. State, Texas Court of Criminal Appeals. Failure to instruct on a confession and avoidance defense is rarely harmless because omission leaves the jury without a vehicle by which to acquit a defendant who has admitted to all the elements of the offense. So I mean, here, Mr. Weaver took the stand, he confessed to the offense. The jury has no vehicle to acquit him. So there is harm. There's multiple harms. That one right there, the trial judge refusing his request, usurping the jury's role.
In other words, what your argument is, without the request being part of the charge, or the instruction without being part of the charge.
He couldn't have a full defense. He couldn't present a full defense at trial.
It took away his only defense.
Correct.
What is the effect of him having been able to get that part of the story in a trial? Was there any objection or hindrance that he was not allowed to put into evidence, kind of his concern and his explanation as to why he fled?
Yeah, so that's exactly what I'm talking about. He took the stand, he provided reasoning on why he fled, and then the defense trial requested it there was objections to the request, and defense counsel and state's counsel both argued. And essentially, after arguments of counsel, the trial judge denied his request.
For the charge instruction.
For the charge instruction. But the testimony was already after his own subjective factors and reasonings on why he evaded.
Where do you draw the line on a subjective thing like that? To what extent, I mean, say there was a widespread similar fear among the public, where do you draw the line in someone having the ability for it to be reasonable and to get that type of defensive charge?
Honestly, I believe that reasonableness is a question of a fact. The jury is a trier of fact. The jury is determined or made up of ordinary citizens of reasonable standards, so to speak, from the community. So if it was for me, I would say leave it in the hands of the jury. Better to err on the side of caution than not.
So it's your position that the rationality of his decision was for the jury and not for the judge to make?
Correct.
Anything else?
No, Judge, that's all I have.
Okay. Anything else? Any other questions, counsel? That's it. Okay, thank you, counsel.
Thank you.
At this time, we'll hear from the state. And you've, been through this before, you know the 3 minutes, and you may, come to this side of the podium, pull the mic over, and you've got 3 minutes to talk to the audience.
Well, first off, your honors, apologize to the court for my tardiness. Now that I've been here, I'll know how to get here next time.
Well, given that you're on the docket at 1:30, can you be here for that?
First off, I'd like to thank, Blinn community for inviting us to, argue before you today. My name is Sterling Harmon. I'm from the Blinn County Criminal District Attorney's Office, and I also, thank you on behalf of my boss, Mr. Josh Cheatons. As you've already heard half the case already, you got an inkling of what this case is about. And I think there's a theme here today. I've been called to argue two cases which both involve interactions between motorists and police officers, which should spark some interesting debate and conversation in your classes and just socially, but, and those are important things to look at and consider in society. I would caution you not to put too much weight one way or the other on the arguments you're gonna hear on this particular case or the one I'm gonna argue later this afternoon if you're still around. But they are instructive and illustrative of some of the issues that do come into play between, the public and law enforcement, and hopefully, what you hear today might give you some enlightenment as to those issues. And again, I thank you for being here to listen, and I thank you for welcoming us to your campus. May it please the court, counsel. The sole issue before the court today is whether or not the trial court erred in not giving a necessity instruction to the jury before their deliberations as part of the written charge. The necessity instruction comes from Penal Code Section 9.22. It is specific in its three elements as to when such an instruction would be warranted. The first, and I believe the most significant, is that it must be shown from the evidence that the actor acted with a reasonable belief to avoid immediate. He acted to avoid imminent harm that he believed was immediately necessary to avoid that harm. The second prong being that harm that he sought to avoid was greater than the harm that could have come from his action to avoid that harm. And the third element of that, which doesn't really come to play in this case, is that what he was doing was not prohibited by some sort of legislative purpose. The key issue in regard to the analysis of this case is whether or not the defendant was able to show, or whether the evidence generally was able to show that, Mr. Weaver, fled in the manner he did from the police officer to avoid, an immediate imminent harm, in that a reasonable person in his situation would have done so. What it boils down to is that Mr. Weaver did not show any sort of imminent harm, that he was in any kind of danger from being pulled over by this police officer. He enunciated no observations, no actions by this officer that would have made any reasonable person believe that I am in imminent danger from this police officer. And
When you say any reasonable person, do we evaluate that from the perspective of the actor in the particular case, or do you believe that to be a generalized, reasonably prudent person standard?
overarching, the case law holds that it is a reasonable, prudent person standard. Of course, that has to be modified by the person in that particular circumstance that the defendant would have been in. That is a reasonable, prudent person in that particular circumstance. That's fairly easy to evaluate in a traffic stop situation, because most grown-ups have been pulled over by the cops at one point or another.
Well, this individual had been pulled over by the cop before and
He
had been
had.
brutalized by a cop as a result of that. having
He
been
had
put over.
indeed.
Do we evaluate that as part of the reasonable prudent person standard as applied to this case? Or are you saying that his past history does not factor into this analysis at all?
Well, if you start getting out into the weeds of every individual's personal history, then you're gonna get to a situation to where you could conjure a situation where anyone, because of a prior experience, a trauma even, would be, you would put that into the evaluation, which the law can't contemplate that you so fine tune, you get down to these very particular matters that essentially the law would say, well, if it felt good to you, then go ahead and do it. You can go to.
But isn't that what the statute in effect allows and requires the trial judge to put it in a charge and then let the jury, as argued by opposing counsel, let the jury decide whether or not that is reasonable?
But there must be some sort of items in evidence that would support.
Well, counsel, we've got an evidence that he testified as to what had happened to him previously. We've got an evidence he's on the phone with somebody expressing concern. Even though he has not testified about that part of it.
Yes.
And we have, at least from my perspective, very unusual thing of a police car pulling up right behind a car as it's pumping gas and just sitting there and doing nothing. Not getting gas, not getting out, just sitting there waiting for the guy and then it's following away. Isn't that some evidence that a fact finder could have included, even if he didn't properly articulate in your mind facts that caused him fear at that time?
The question I would have is, what imminent danger was posed by that police officer pulling up behind him? That was not articulated.
You have to articulate it for a jury to
Something
infer.
must be, yes, Your Honor. That something must be articulated. And certainly there's not a particular rule or standard as to what that articulation must be, but there must be something.
So you don't think that the evidence that was in the record of the previous assault by a police officer, for which the officer, I think it's in evidence that the officer was found guilty of.
He was.
And so you don't think that the articulation by this defendant of the fear of that being repeated is sufficient to get the instruction?
No, because if we had that as a rule that, okay, I had a bad experience with the cop once upon a time.
It was a bit more than a bad experience.
Oh, yes, it was a visual impression, it was assault. And I don't intend to be flippant about the situation that Mr. Weaver had in his past. But if you credit that towards that being a reasonable belief without anything more, then you wouldn't have traffic stops. You would have people flying around neighborhoods at 90 miles an hour, crashing into cars and trees because they have a recollection of that makes them nervous around police officers.
But the standard that we have to apply
Yeah.
is some evidence of reasonableness. And that's a very, very low standard to be entitled to the instruction. And the Court of Criminal Appeals has repeatedly and recently reemphasized the need for trial courts to give these defensive instructions.
Yes.
Because the burden is so low. So why is it that the specific facts of the prior assault, the fact as confirmed that this was on his mind by the fact that he called his significant other and was on the phone explaining that he felt threatened at the time, why is that not sufficient to be some evidence that the trial court should have been aware of and therefore given the instruction and let the jury decide the reasonableness of Mr. Weaver's concerns?
Mr. Weaver's testimony, and as well as his girlfriend's testimony that he made those statements, those are all well and good. But he did not articulate any reason why he felt that he was in imminent danger from this particular officer in this particular situation. It might be helpful to jump over this and look at the harm analysis. One of the cases that I cited had a quote from the opinion that reasonableness is judged from that of a reasonable, prudent person, not a paranoid psychotic. I don't think Mr. Weaver is a paranoid psychotic, but I do think that he's a drug dealer. And if you go on to the harm analysis, well, what would the jury have done with this instruction had they had it? Well, when he eventually gets pulled over, what is in evidence that he had drug paraphernalia, he had $12,000 in cash, he had drug scales.
But doesn't that all get back to the reasonableness of his belief of a problem and the reason he might have fled, as opposed to the harm analysis that we get to after determining whether or not there was error?
Well, I would analogize that the phrase a paranoid psychotic is not a reasonable standard, nor should the actions of a reasonable drug dealer be held into account either as being a reasonable response to the situation. So as I say, that's directly addressing the harm analysis is overwhelming evidence of why this man was fleeing. And it wasn't because he had some kind of a fear of police officers who were imminently about to kill him. He did not express any sort of fact that would have led a reasonable person to believe that. This was a
What was the statement that was in evidence of it that he made to his girlfriend on the phone? I think something to the effect of, I think they're about to mess with me.
something to that effect.
Some evidence of fear of that particular officer at the time?
Oh, that could very well be evidence that he was in fear, but why? There's nothing in the record that shows why. Is he unholstering a gun? Is he hitting him with a pit maneuver? No, none of that is in that.
You say there's no evidence of that in the record? Are you talking about of what the officer was doing or?
Yes.
The fear, well, I mean, as Justice Smith pointed out, the unusual relocation of the police officer's car without actuating, his, lights and then following him out of the parking lot as he was trying to leave, or as he was leaving after a pause. You don't think that?
Well, Mr. Weaver's perception of that being something unusual, but how is that threatening? Police pull up behind people all the time. How is that articulated as being an imminent threat?
Well,
I suggest that it is not.
Well, you can combine that with the fact that the guy had been assaulted by a police officer formerly. You don't think that can convey, at least in his mind, that there is a real significant threat?
But that is not reasonable unless there is some sort of less of what the officer has done. What has he said? What, is he unholstering his gun? Is he flying?
Is he pulling up behind him and sitting for 3 minutes and not doing anything at all?
A police officer can do that, but it doesn't convey any sort of threat of harm to you.
anything else? Thank you, Counsel.
Thank you, Your Honor.
You got 5 minutes of rebuttal. You may proceed when ready.
Thank you, Judge. May I please report, counsel? Section 1.01 A42, the Texas Penal Code defines reasonable belief. Reasonable belief is one that would be held by an ordinary and prudent person in the same circumstances as the actor. All right. The first element to necessity justification is the actor reasonably believes the conduct is immediately necessary to avoid imminent harm. Both of these are from the perspective of the actor. Here's Mr. Weaver. Mr. Weaver, with his prior history with police, one, but two, the fact that an officer is sitting at a gas pump for 3 or 4 minutes, he could have pulled him over, got out of the car, and written him a ticket right there. He didn't. He decided to wait until he's driving down the road. It's midnight. It's cold. It's dark. There's a delay because Officer Merrick is having to put on his jacket. There's the testimony from the significant other, Ms. Jackson, that he's jittery. He's been jittery around police officers as well. That's in my brief.
How do you factor in what the state wants us to also consider, that he has the drug paraphernalia, the cash? How do we factor that in?
I mean, those are separate offenses. So, I mean, the state could have brought additional offenses. This is a one charge indictment for evading arrest.
How do we factor that into, or do we factor that into whether or not the trial court erred in giving or not giving the instruction, and then whether or not there was harm in not giving the instruction?
So again, I believe that evading is a continuum. At the beginning, did he have, in his own mind, from his perspective, did he have a reasonable belief that he was about to suffer imminent harm? And so that should have been a question for the jury. Now, later on, is going 80, 90 miles per hour in a residential area, turning off your headlights reasonable? Probably not. That's a question for the jury, though. Throwing out money or drugs is tampering. They could have brought additional charges. They could have indicted him. This is a 1-count indictment for evading arrest. That's what I would answer, how I would answer the court.
Okay.
So.
Yeah, I mean, you've got a couple more minutes if you want.
I understand. I'm done. If there's any other questions, I'll be glad to answer whatever questions are left.
All right, counsel, thank you. This case is submitted and y'all are excused from this case, but we'll look for you at 1:30.
Yes, sir.
Thank you, Justice.
Yeah, y'all may leave the courtroom or stay. We're gonna, go into some Q and A. For those of you all that have joined us, since we started, I need to let you know that the second case that was supposed to start at 11 o'clock, we had a problem with, one of the attorneys in the case had a family emergency and was unable to be here today. We granted a continuance in that case late yesterday. And so, it will be delayed until some future date, but, we will have a docket, we will have a case at 1:30 this afternoon. And so that case is over. As anybody involved in the law knows, we can't comment on that specific case. But we will open it up to some time for Q and A. At this point, how many people, have joined us since we kind of started? If I could have a show of hands. Okay, there's enough here that I'm going to answer the Dean of Humanities question again. You need to know how to write. That she asked the question of your academics that make you good for the law. What helps you become a lawyer for our profession? What would I recommend a student take? What I'm focused on is academically, you choose something challenging. And as far as communication, I go outside the law and the academic environment, work in a field in which you deal with the public, but in the academic environment, take courses that teach you how to write, how you to communicate in writing. Justice Smith was very specific in 2 or 3 history courses in addition to your English courses, as well as an accounting course, so that you can learn to balance a checkbook and read a financial statement. And I endorse those as well. So with that as the first question, we open it to more general questions of any type that you may have about the law, what we do, how we do it, what has happened today in a procedural standpoint. We'll be happy to throw it open to you all. What we did before, if we let the visiting judge kind of run, but no, you have to stay there.
Okay.
You can't leave yet. Questions, anybody? We had a lot this morning. If you did come in, I do encourage you to go back and we were waiting on the state's council to get here for about 30 minutes. And so we answered some questions during that time period. We do live stream on YouTube. It will remain and stay up there. And so, you can go back and see those questions that were asked, but we have a new one. Yes, sir.
I was wondering from the time that you started law to now, how the cases that you see normally change. Like, do you see more of something that you don't see anymore, or less of something that you see more?
I was a trial judge for almost 23 years before I came on this court. We never saw something called aggravated sexual assault of a child or continuous sexual assault of a child. What I hear from my fellow judges around our 18 counties, especially here in Brazos where I live, almost every other week, that's what's being tried. So that and part of it, and concurrently with that, spousal abuse. We didn't used to have that a whole lot when I became a district judge, but now we do. It's happened before. Sadly to say, we just weren't aware of it. And now we are, and we're seeing that a lot.
Other thing that happens is that the cases that come through the court are largely reflective of our society. And so they will ebb and flow based upon both things that are happening in society, as Justice Smith mentioned, but also changes in the law, economic things. I mean, for example, I think the chief mentioned earlier about medical malpractice cases. When tort reform came in, it made it really difficult to sue a doctor. You have to meet a burden very early on. It's tough to do. Okay, so we see much lower levels of those type of cases. Back in the day, before there was what's known as no-fault workers' compensation, if you got hurt on the job, you had a full trial to determine what you're entitled to. They changed the system, back in the nineties to where in those cases, the employer through insurance is generally on the hook without having to go through an entire trial process. And so we saw a huge fall off in kind of the on-the-job personal injury cases. For example, right now, if you watch television, I'm sure you see that commercial vehicle accidents are the thing that, if you're a plaintiff's lawyer, representing folks, that holy grail is if you can get a commercial vehicle accident case. Well, that's driven by economics of, if you get hit by some normal schmo driving down the road, chances are they either have no insurance, very little insurance, you can have a terrible accident, but there's not financial wherewithal there to pursue it. Whereas commercial vehicles have to carry a certain level of insurance. So when you see those commercials, have you been hurt on the job? Have you been hurt by a commercial vehicle? A lot of times that's driven by the economics. So the courts are largely reflective of what's going on in society as a whole. Judge Smith mentioned, changes in Brazos County and what we see. A lot of it too is population driven. You'll have cases, the criminal cases, the family law cases really increase sort of directly proportional to increases in population. And so those things tend to reflect society as well.
I'll echo that, from what both have said. Another area of the law that the legislature has been active in is called the Texas Citizens Participation Act. You hear that when the legislature first passed that, it seemed to be the panacea for every misstatement that any person ever made. And if it was litigation related, it spawned hundreds, if not, thousands of cases. We had a day in Waco where we scheduled all the cases that we had that involved that statute. And we just heard all those one day. Y'all may be familiar with the Michael Morton Act. It's a criminal discovery statute that was passed. We had very limited criminal discovery. Let me back up. We had very limited discovery from law enforcement or the district attorney's office in Texas prior to Michael Morton's conviction. And then after 23 years, finding out that he was not the assailant and murderer of his wife, that it was definitively another person that was convicted as a result of DNA evidence. As a result of that problem, the legislature greatly expanded the level of discovery that can be obtained in a criminal case from the state. We are still working through that statute. What is discoverable, what is not, what are the consequences of the state's failure to discover. So in direct answer to your question, our docket changes a lot over the course of the time, for example, that I've been on the court. Two things about it is it is responsive to what is happening in society as recognized by the legislature. The result of that is also that it makes it very complicated. The law itself becomes more and more complicated each time the legislature meets and modifies and changes, adds to the requirements. As you've heard these lawyers talk about today, there are elements in factors that result in the violation of the law and the defenses. It becomes more and more complex. In criminal cases, because most defendants are represented by appointed counsel, we get more criminal cases appealed. Those that are tried, more of those come up as an appeal. The result of that is we see the same thing repeatedly sometimes from counsel, but the fact is they just keep coming. It's like a herd of buffalo. They just keep coming. So it never seems to stop.
Like that, one other little small piece is if part of your question was driven by personal economic considerations for career choice. If you can stand to be a family lawyer, I can't imagine that you won't be able to find plenty of work because, you know, the whole family law, divorce, child custody, has exploded with regard to both population and the frequency of the litigation. And so a lot of the courthouses, you know, some courts in bigger counties are specializing in having the criminal courts and the civil courts and the family courts. Anytime you have a mix, you'll hear from judges, they're just buried in family cases because there's so much family law because divorce is so prevalent, based on societal things. I mean, when I was a kid in the 70s, my folks divorced when I was 3, and that was so unusual that like the Big Brothers Big Sisters program reached out to me and said, "Hey, we heard your parents are divorced. Would you like us to give you a big brother?" Well, now, you know, it's so common that it, you know, you don't think much of it. But you know, there's a ton of family law, a big need for it. And now they have places where those folks can pay your lawyer bills on a credit card. So that I think has helped the legal market as well in that regard.
Good question. Yes, another question back here.
Yeah, Leah Schubert, legal counsel for Blinn College. Can you discuss a little bit how the practice of alternative dispute resolution and mediation has affected your court, if at all? And as a fellow mediator, I'm a mediator as well. We have a very active mediation program here. Our dispute resolution center is a nonprofit that's very active in this community. I know most of our paralegal program attendees will go through that training. So how has that affected the practice of law and also the practice of your court?
Let me first say, the reason I refer this to Jeff Rose is because after he left the bench, he has become one of the really recognized mediators in the state for complex cases and has done a lot of that. And so much so that we have to get on his schedule well in advance for a day like today to get him away from mediation and down here to sit with us on the case. So
sure. I mean, just from the very basic standpoint, for those who may not be familiar with the system, mediation is a process where parties that are involved in a lawsuit or a fight, a lot of times because the court requires it, a lot of times voluntarily, sit down at some point, say, okay, we're going to take a day off from the fight, spend it kind of working through our issues. We're going to have someone be the neutral to help us communicate, help us look for solutions and see if we can resolve this case rather than continuing down the path of being in court. And to me, it's one of the few things in litigation that makes sense. If you're going to get in a fight, let's have a conversation at some point, say, what are we fighting about? How can we resolve it short of punching each other in the nose? And let's look at ways to do that. But amazingly, you know, until the late 80s, early 90s, it was really not very prevalent in our court systems. And it kind of came into vogue right about the time the courts also started to be overwhelmed from a volume perspective due to some of the things we've already talked about. And so it just sort of meshed in. But the hope is, of course, that only cases that just can't be resolved through agreement are the ones that get to trial. But yeah, because when you go down, you have a case go to trial, it's not just you're taking a judge's time, it's not that you're paying lawyers, you're also calling on, you know, a pool of 30 people from the citizenry that are going to come in, take a day off work, go down for jury duty, you know, 10 or 12 people that are going to get selected for that jury and have to spend a week listening to it. And so to me, there really should be an obligation on the parties to have worked through and try to resolve something. And the hope is that through this process, we get the numbers down and it helps, you know, so I kind of see what I'm doing as an extension of what I did as a judge, which is, you know, try to resolve cases, try to help the courts clear their dockets. And so, you know, in any given year, I'll mediate between 80 and 100 cases, and they're generally large civil cases. You know, 80 to 90% of those will get settled at some point prior to the time they go to trial. And so, you know, when I was in the Court of Appeals, I was doing about 150 opinions a year, disposing of cases. I like to think that I'm, you know, maybe 3/4 as productive as I was then, but it's a really important process. And the other thing you mentioned, you kind of said ADRs and more global, but the process of arbitration, which a lot of times people get confused. Mediation is voluntary. You go spend one day, nobody can order you to a solution, but you'll work with a neutral to try to come up with an agreement. Arbitration is where the parties in advance sign into their contract. Hey, if we get sideways over this contract, we're not going to sue each other in court. We're going to agree to go through this process where we essentially take it out of the court system and go through arbitration, which grossly oversimplified is sort of a private litigation and judge system. And so I do those as well. And so hopefully those also help kind uncongest the courthouse, because as we just went through an election season, you saw a lot of policy arguments about needs and wants as far as society and what we do with tax dollars. Sometimes the courts don't get the best shake out of that, and they're always taxed. Taxed not in terms of monetary, but taxed in terms of overwhelmed with the need. And so, Chief Justice and I were both chiefs together, and one of the things that we did was every session, we would be some of the ones that would go down, talk to the legislature about the courts, the budget, and what we need. But as he mentioned, up until recently, there have been 80 appellate judges for the entire state since, I believe, 1980. Is that correct? So the number of appellate judges hadn't changed. I think we just added maybe 3 more through adding a different court to handle business cases. And so a lot of times the courts don't get the growth and the expansion that they need to keep up with population. So I think ADR, or alternative dispute resolution through mediation and arbitration, has really become recognized as something that's important as part of the litigation process, important to the courts. And even in a lot of places, courts themselves are starting to have opportunities for an ADR process while you're in the litigation.
Yeah, let me tell you an example really worked here in Brazos County. Somebody comes in to get a TRO for a family law case.
You might explain what that is.
Temporary restraining, okay? One side or the other comes in, asks us to order something. And under the law, we are required within 14 days to have a hearing. Well, our judges got together and said, if we sign a TRO, we're also going to send an order there's to be sent to the Dispute Resolution Center, which you're talking about, Ms. Schuman, to see if they can work it out. Our level of TRO 14-day hearings disappeared. Not only very often would they get the TRO issue settled, they come in with an agreed decree of divorce. Simply because they had the opportunity to sit down, as Justice Rose said, have someone help them work through their issues and get it resolved. I don't know, and we send cases at our court to mediation as well. If we think there's a reasonable chance that they can resolve something among themselves. That's all what I was told people that came to me when they were upset that I had sent them dispute resolution. I would tell them, you guys can agree to do things that I could never order. I wouldn't have the authority under the law to do what you all could agree to. So go see if you can agree. And more often than not, they came back and I had an agreed judgment or an agreed dismissal, and we got that case resolved.
And I'm gonna leverage off of your question and ask my own of my colleagues. At what stage of proceeding do you see cases in mediation? And when is it most likely to be successful?
You see them at all phases, and
You might explain the 2 fundamentally different phases of the process.
you're talking about
Trial
and appellate.
Yeah.
Well, if that's the division, you seldom see them on appellate, which I had hoped that I would have some niche because I've been chief of an appellate court that I would get all this mediation. Maybe 3 or 4 times a year I'll get a case that gets all the way to the appellate. And while they're waiting, because the appellate process can take a while as well, you got time to mediate, you might as well mediate. But a lot of times they've already mediated maybe several times by that point, and they feel like they've kind of exhausted themselves. But I thought you meant more in terms of the life of the dispute, because it would really make sense to say, hey, we have this dispute, before we go spend a bunch of money, let's get together, see if we can resolve it. And so that really is very logical. And I'm involved in kind of some national movements for early dispute resolution. But one of the challenges of that is that you still have this mentality, and a lot of times it comes through lawyers of, we need to know every single thing about this case. We need to have done what's called discovery. We need to have sent the other side all these questions. We need to have gotten their testimony before we can resolve something, sort of a fear of missing out type thing. And so when cases come to me early, like just yesterday I had a case, and it hadn't had any discovery done. They came to me early. And I said, it's great that you're to me early. I'm going to tell you that at some point in the day, you're going to have to bear the risk that there may be something out there you don't know yet, and kind of live with that fear of missing out, if we're going to get something done. And the alternative is, you can go do the discovery, but you're going to spend another couple $100,000. And when you come to me in 6 months or a year from now, we're going to not only be mediating over say the $200,000 that you think you owe one another, but each of you are gonna have another $150,000 in attorney's fees, and that's gonna be what keeps the case from being able to settle. And so it's a real challenge. So, I find that a lot of times early on, it can be a challenge. Some cases you can get it. Generally, it's with parties that have already been through that type of thing before, and they kind of know how the drill goes. And a lot of times those that come in there too early, they're back to me in a year and we get it settled, but it's the challenge of dealing with the attorney's fees. One of our judges in Travis County used to say that lawyers have priced themselves out of the dispute resolution business. And it's unfortunately a little bit true. It's just really expensive to go through a process where both sides have lawyers, you're doing discovery, you're having to do court type stuff.
I did a little bit of mediation before I became a judge, and I echo everything that Jeff has said. I think earlier the better, but at the same time, sometimes even in the appellate context, both sides thought they were going to win the case, and all of a sudden now there's a judgment, and one side says, "Well, I don't think I should have to pay anything." The other side says, "Well, I think I should have gotten more." And so very often we can send those people in mediation and they can achieve some kind of resolution without going through the appellate process and incurring even more attorneys.
Right.
I'm gonna ask my staff attorney a question. Polly, has the railroad order gone out? Okay, then I can't talk about that one.
Tell us about it, Chief.
No, we're gonna adhere to that. It's hard to make that one hypothetical.
That is one of the things about this job, and especially on the Court of Appeals, is you come home at night and you talk to your wife over dinner, and there's not a whole lot you can say sometimes.
About what happened in your day?
Yeah, what happened in your day? Well, we read a whole bunch of stuff, and, yeah. Chief Justice Gray said something funny down at the water cooler. My trial court, you come home every night and you've got stories, and it's,
Because it's all in public record.
Right.
It's all out in public.
Yeah, my daughter is Associate General Counsel of Litigation in the Department of Homeland Security, and I always love to wonder what she does. And she always tells me, "I'm sorry I have to kill you."
We're gonna take a little break. In 30 minutes, we were supposed to have a formal Q&A session. If you want to be back for that, I understand that from Robert that there was a class that was specifically being given credit for attending the Q&A session at 12 o'clock. And we've answered most of the questions. We hope that somebody will be here at noon from that class to get that extra credit for being here, but we're going to step away for a bit. If you had a burning question that you didn't get to ask and you can't be here at 12 o'clock, come see one of these two guys now. And but now we'll be happy to try to answer individual questions, but we would like for y'all to come back at noon.
And at 1:30.
And at 1:30 we'll have another case. Let's see, for the students in the room, the afternoon case, I particularly think you would find interesting. It's applicable to everybody, but just to kind of tease you a little bit about the case, it is the classic situation of 4 people in a car that is stopped. And what can each of the occupants lawfully do? And what is the interaction between the police officer and the various occupants? Remember, the car is stopped for some type of traffic infraction. And then you've got 3 other persons, we'll say, besides the driver in the car, and what happens to those other 3 persons as a result of the stop. So it really is very educational. In fact, one of my staff attorneys and I went to another school to talk about constitutional search and seizure, and we were talking about a fact pattern that is amazingly similar to this actual stop that we'll be arguing at 1:30. So I do encourage you to come back for that. So we stand adjourned for until noon. Thank you.
Thank you.
All rise.
I'll get extra credit.
Do you need individual?
No, I'm afraid.
We'll make sure, we'll make sure we have. We're all. So I'll. Probably imagine that. Yeah. We can go ahead and do it, but.
Yeah. Yes.
If anyone else would like to hear from the program, to get a picture also. Oh, yeah, yeah, I'll let you know. I think if we have any more, like I said, we might try to. That's all, you know, bridge. I thought, I called them. Take a note. Thinking we can go ahead and put page. And if you want to stick around, we're gonna probably have a phone call in about 20 minutes. And, I mean, we don't know how many more fees we're getting. So we might be able to, I printed out. Yeah.
I know at one time. I don't know what the atmosphere is and stuff. I don't think you're gonna try. Yeah. Yeah, I have to go through There's some people, yeah, take it from one spot to the other. Busy person. Want to show. That's what I want. Yeah. First, really quick. When they got me here. I think it's how that many you need. Right. I think 4 hours first. That means much.
What's the name? This, whatever. They just did that. 200? I know it's sorry, what's that building? Yeah, right. Oh, we are covered. Okay. I mean, she's like, I saw that. All right. And. Yeah, I. It was like, I. I wasn't trying to do Oh, yeah. Oh, my gosh. This it was one of those things. But that's kind favorite London. Not just we were home barn. So doctors. I just.
Yes,
Very good.
oh, yeah.
And he. Have a good day. Wonderful. But yes. Yeah. But you know, her husband is. That's not like a word. My dad is. Yeah. That's my youngest. Like way off. Yeah, like. Yeah. One of the things that me. Not literally on the range. Yes.
My favorite thing is like.
Yeah, I'm just trying to think of the day. No, right. Because I remember that.
Yes, I do. Yeah. She just wants.
I don't, yeah, I think.
Yeah.
The class.
Yeah, but it's certain.
Yes.
Okay, so that's like, so, they'll let me do like. Just. Other way we use headers, each paragraph. They're not.
Yes.
No, I don't think so.
No, you don't even put that.
The reason you're doing charades is the use humanities, so that it's both sides and the users. The reason they do that, every discipline has their own, and one of the things that, since she's not here to say, it's one of the things that school districts really mess you up with, is they make you think in a lazy way to go. The problem is, it's very outside of humanities, it uses that. So you need to go with what the actual division or it's been a long time since I've published a paper in using grading, so I'm going to stay. But I'm sure it's updated. Yeah, and also you have consultants. Ask questions. Very cool. Yeah.
Yeah, no, good luck.
Oh, yes.
Right.
No, I can't. I should, that's right on the letter. I didn't.
Yes, you probably have about.
All of our last.
Good man.
He was not. Yes.
Let me check that. Okay.
Who's not here?
No.
Yeah.
I forgot.
Okay, on that wall.
Yeah, like next to the bench.
Okay, no, absolutely. Give our students, your Blinn paralegal students who would like to be in the picture,
Over this way. All right, where you go? Right over. And then you guys can kind of-
Yeah. I don't think else politics very much. You guys got a lot.
I'm gonna ask them
That's why I went and got one.
Thank you.
Yeah, put him like kind of off to the side.
Yeah, but you gotta figure out how we're doing it. Yeah, I'll put maybe some of the shorter people on the ends. You guys are kind of on the ends. We'll put the taller folks in the back. I'll have to. A little. Excuse me. Can you scoot over? I'm gonna put you over here. I maybe need one other person over in here, maybe you look a little more. What's the word I'm looking for? Okay, yes, there. Let's see. You two appear to be in the top. I'm just doing.
Anyway, you get us wrong.
Yeah. Students, you and step forward, you. You can go there. Maybe I'll put you in, you here. And then can I ask you to step over next to green jacket lady? Sorry, let's try. Okay, sorry, I don't want to leave right now. Dean, maybe we'll put one on each end.
You're actually very polite. I used to have them, they go, hey, fat boys.
I actually love it, so. Here comes our question. Okay, here we go.
You're on.
And Mr. Sandra, I think you can kind of start ways to, being,
Thank you.
yeah. I'll make this with you.
Thanks for looking forward to it.
All right, Mr. Stanbury, I'm gonna ask you to move, maybe over between these two ladies with the white. There we go. That looks. All right, I'm gonna count 2, 3. And make sure my camera. 1, 2, and 3. 1, 2, and 3. April, could you scooch a little bit that way? There. And 1, 2, and 3. And 1, 2, and 3. Let me just double check. Oh, that was low. That was slow. All right, thank you, everyone. I appreciate it.
Before anybody moves, Jeff, I'm gonna ask you to step up and move your chair out.
Good.
All right. Now, yeah, we might need to rearrange a little teeny bit. All right, yeah, I think. Maybe if you could scooch a teeny bit back, yeah, like, I'm sorry, I don't know your name, but could you scooch the camera? Could you scooch back a little so you can move his chair? A little, there we go. That looks good, a little more center. See everybody, see ya. And we'll do it again. And 1, 2, and 3. 1, 2, and 3. Dean, yeah, perfect. And 1, 2, and 3. And 1, 2, and 3.
Ding dong.
Hey, Chief.
Thank you.
Chief, you want to get those guys?
Hey, how do you know?
If you have any-
Hey, I'm volunteering.
Yeah, probably.
You guys still encourage the paralegal students to get individual pictures, things like that too.
Y'all are gonna have.
Yeah, send them to me.
Bug around.
That's true.
You remember that saying?
I.
This is solely because of him. Look, I'll get it behind me. Yeah, we'll shoot again. I don't know who camera we're gonna use.
You gotta come back.
I can send it to you. I have your email.
Okay. Fine.
Right. I think we just want to scooch over that way a little bit, be centered. Okay.
Second.
Yeah.
And are we ready? One, two. One, two.
You don't get to share it with this.
Now we're gonna break the camera.
Yeah, thank God Rose, man. I know, you got it.
Just stand here on the, because one of the things I failed to do is I think about it. One of those
And one, two, and three. One, two, and three. Let me double check. Looks great.
All right.
Appreciate it.
All right.
Steve, we actually are supposed to be having a Q and A going on here.
I'm gonna give you all my thank you.
Just waiting for
On the
you.
road.
Good to see you.
Hey, thanks for picking up.
Thanks for
Glad to help. We all love you.
Appreciate it.
You bet. You like it? Yeah, yes, sir. The most dangerous thing about this drive is the phone calls I will have to receive.
Keep it between the lines.
Yeah, thank you.
Thank you, Judge.
Be
silent.
Whoa.
I know y'all don't know what just happened, but if we could give a round of applause for Jeff Rose who's leaving there. Jeff sat on the first case, so the second case, as most of you probably know by now, was canceled, the one at 11 o'clock, so we already had a lot of Q and A. First while we were waiting for one of the attorneys, and then post-case argument, we had some more Q and A, but we are happy to repeat questions because there's people that have joined us that did not get to hear our answers to the first, but we're here to help you understand what has gone on today and to basically answer any questions you have. So fire away. If there's somebody out there, please let us hear something. And I'll ask the first question of Justice Johnson, since he was not here to explain his path of how he arrived at being a judge on the Court of Appeals.
Well, it really started out whenever I was an assistant district attorney in McLennan County. I worked for BDA in McLennan County at the time, and I prosecuted criminal cases for a period of about 4 years. During that time, a lot of satisfaction in seeing the justice is done and that victims are represented. And so then after that, I received an appointment from the county commissioner to serve out a term as a justice of the peace. And that was my first judicial experience. Besides working with a lot of law enforcement judges as a prosecutor, that was my first experience as a judge. And then I went into private practice, and the judge I worked for the most while I was in the DA's office announced his retirement, so I announced I'd run for his seat. And I served in the 54th District Court of McLennan County for 14 years, trying criminal cases. And then in, 2020, I stood for election at the Court of Appeals when retired Justice Rex Davis announced his retirement, so I announced that I'd run for his seat. And so that's how I wound up on the 10th Court of Appeals.
The question also was, what academic courses would you recommend students that are wanting to pursue a career in the law? What academic should they say? And then specifically with regard to writing.
Well, writing is an important aspect of the law, especially in law school and then beyond. If you want to do appellate work, you still have to draft pleadings and things like that. But the writing style for pleadings is so different from actually writing briefs and things like that. I would recommend taking English classes that require writing. Even though legal writing is a little different from what you see normally with essays and things like that that are typically taught in English classes, but having a command or a mastery of that is often helpful in practicing law. I think also having a background, my background as an undergraduate was in business, and whenever I was in private practice, I relied on my business degree quite a bit because you not only practicing law, but you're running a business, you have to meet a payroll. And you have to make sure that, your taxes get paid and everything is taken care of. So some business classes, if you're not a business major, take a generalized business course, so at least you're familiar with some of the terms. I think that's important. And then with regard to experience, some of the most valuable experience I received, was working as an assistant DA. And I'll tell you that you can do internships with most district attorneys' offices. So if you don't want to go, spend, 4 years as an assistant DA like I did, at least do some internships, go watch some trials. And maybe do an internship for a judge, at least do that instead of working in that situation.
Another question that was asked, young man sitting over here had asked it. We all answered it, but thought I'd give you an opportunity. You've been doing this a while, at different levels. How have the cases changed over that period of time?
Well, because I was a prosecutor and then a judge in a criminal court, I haven't seen a big change in criminal cases over my career. Now, once I wound up on the Court of Appeals, of course, we handle civil cases, but about 60% of our docket is still criminal matters and 40% civil. And so, the only one of the big changes I noticed, when I was, a criminal trial judge was, and as an assistant DA, is they used to just pull your voter roll. I mean, they used to just pull jurors off the voter rolls. And so all you wound up with for jurors were people who registered to vote. And I think people who register to vote feel like they have a vested interest in our system of justice and in our democracy. And those jurors were different, but then those jurors had not different, they just had they had a different perspective, put it that way. And then what the state did was they rolled in all the people who have driver's license. And so that's a much more broad base of people. And those jurors, I started noticing, had a bit of a different perspective. When you include a broader spectrum of society. And that's one change I've seen, not necessarily the cases, but sometimes in the jurors. And this is unique just in my county, McLennan County, where I came from, was we used to use the 4 district courtrooms, and that's the way we impaneled jurors. So the first courtroom was the 19th, then you went down to the 74th, then you went to the 170th downstairs, and then usually the county court or county commissioner's court. And we put jurors there. Well, the people were always told to go to the 19th first. So the people who got there the earliest and on time, usually before the time, they were all sent there. And then they were sent, then the next group was sent to the next court, so on and so on. Well, because the 54th always handled criminal cases and had a lot of witnesses waiting, we always got the first jury panel. And they always pulled the first jury panel from the 19th district courtroom because it was full, it was ready to go. Well, the 54th always got the people who were on time, punctual, and conscientious about that stuff. And when we got a central jury room, we got a mixed bag, and it was a different perspective by those jurors. And that's just interesting. You wouldn't think that just changing the room jurors sit in would affect the juries that you wind up with in your courtroom, but it did in the Blinn County.
Another change the legislature made while you were on the bench, I believe you were the judge of the 54th at this time, they changed the way that we impanel grand juries. Could you address that and, in particular, explain how it was done before and then how that got changed and then the impact of that change?
Of course, the grand jury meets in order for the district attorneys to be able to present cases for indictment. And the grand jury will present a true bill of indictment or a no bill, meaning they don't think there's probable cause to proceed with the case if it's a no bill. If it's a true bill, they do think there's probable cause. And that's done by 12 people who are selected in the community. The selection process is very, like Chief Justice Gray said, it only takes 9 to get an indictment, And so you get 9 out of 12, and that's the vote to indict, and so then you can hand down an indictment. What changed was, when I first became a district judge, we used to, select 5 people, and the statute requires 5 individuals, no less, or I think it was no less than 5, and we always did 5, from different parts of the county. And they couldn't all be from, one neighborhood over in one part of town or one part of the county. And so you had a diversity because you had to select them from different parts of the county. And then they would pick 5 people. They could pick more than that, but we always used about 25 folks, and that usually was able to fill a grand jury of 12. Then they picked 5 people, and they would nominate them to be on the grand jury. So we had what was called the grand jury commission, the initial 5. Then we had the panel that would constitute the grand jury, and that was the 5 individuals that were nominated by each member of the grand jury commission. And so back then, there was, it was a different style. It was called the key man system. Probably couldn't call it that anymore, but that's what it was called back then. And then, there were some problems with it in one particular large county where people were putting friends on there, and they were talking to the grand jury commissioners about putting other people that they know on there, and they felt like it was interfering with the process. So they disposed of that, and now we just pull a grand jury panel as if you would any other jury. So it's pulled from basically everybody who's a registered voter and everybody who's got a driver's license. And usually something about 100 of them in our county and McLennan County, and try to get 12 grand jurors out of that group. And the reason we summoned so many more is because if a grand jury commissioner was going to put someone on, they would talk to them first and say, hey, I'm going to put you on the grand jury commission. Can you do this? They meet twice a month for half a day or a full day, so they kind of pre-screen folks that would have the time to be able to do it. Now we just pull a regular jury panel, and so a lot of people can't do it because they have excuses that are statutorily approved, or they just have reasons, medical reasons, whatever. And so,
Are the same qualifications for a regular juror applicable to the grand jury that is selected that way? For example, felons, and they have the excuse for children in school that they're responsible for, or age, they can get out if they're a certain age. So are all of those applicable to the grand jury?
Most of them are applicable, and including college students. If you're fully enrolled in an institution of higher education, that's an exception. The legislature allows you to not have to serve. And so there's generally the same type of exceptions for those folks. But then we pick 4, and one thing that the legislature added when they did the new system was we picked 4 alternates. And so if one grand juror cannot continue their service, they're not substitute grand jurors, but if one person that's on the grand jury cannot continue their service, let's say something bad happened, car wreck, whatever, then we can bring in one of the alternates to sit in and fill out the rest of their term.
Do you still only need 9 to indict?
You still only need 9 to indict. When I was a prosecutor, the first time I went through paneling the grand jury, I went upstairs with the DA's office, and they really had to warn it. They said, you gotta have 9 here, preferably 12, but you have to have 9 because if it's just 8 people, it's just 8 people sitting around talking about criminal cases. You're not a grand jury anymore.
Okay, Steve, you want to add anything to the answers on those questions?
I'll just add an answer to the selection process. When we used the commissioner's method, we had a broad-based representation that looked like our community. Matt and I, when I was district judge, we would select the people who would serve on the grand jury. And I wanted to be sure we had white grand jurors, Hispanic grand jurors, African American grand jurors that looked like the county. When we were then left only with a regular pettit jury panel coming in, we were bound by the people we got. And I'll never forget the first pettit jury I was required to use for grand jury. One African American out of 40. And so that totally defeated my ability to make grand juries look like our county. And it's all because of one county in Texas. Who shall remain nameless, but it's a little bit farther down Highway 6, over that way.
All right, so that gave you some questions to, or some thoughts, responses that maybe will, generate some questions from you all, so. Open-ended, ask your question, this is your opportunity. How the judicial system works, I've already gotten the Dean of Humanities thumbs up on the writing, the need to know how to write. So.
I'll get us started.
There you go.
My name is Leah Schubert, I'm legal counsel for the college, and I asked this question earlier, but I also wanted to present it to this panel as well. What is the influence of alternative dispute resolution, mediation, and arbitration in the law? How has it affected the legal practice, and how has it affected your courts or the courts you sat on previously?
Well, the court I sat on previously was a criminal court, and so alternative dispute resolution, it doesn't really work there. We just don't, it's just not used in the criminal setting.
How would you characterize maybe plea bargaining as part of that process, and has that changed?
Well, when I traditionally think of alternative dispute resolution, I think there's a mediator, someone in the middle from between the parties, between civil litigants or something like that. Plea bargains are agreements reached by the parties themselves without an intermediary. And so, I mean, plea bargaining is technically maybe a way to resolve a dispute, but it's not what I think of in the traditional sense. And plea bargains have been going on large scale since the early 1970s here in Texas. There was a time in the past, back in the 50s and 60s, when plea bargains were just frowned upon. And, I mean, you know, it wasn't something that district attorneys did very often. It was kind of an exception to the rule. Now it's way more the rule than it is the exception. I think it's valuable. I think it's a valuable tool to help people resolve their disputes. One thing that an experienced mediator told me one time is he always tells the people that have a dispute, litigation pending, is that right now, you tell each side is you have control of your case and how it's resolved. He said, once you go to the courthouse and once you let a jury look at this case, you lose all control, and the jury's gonna do what they want to do, or the judge is gonna do what the law requires them to do. And so it's valuable, it saves courts time. I mean, the dockets in most courts are full, and so it's a useful tool.
Yeah, the only thing I would add, is, it's the same, one of the things Matt said, and I just said it a different way. I would tell parties that came before me that I wanted to go to mediation, I would tell them, you guys can agree to do things that I can't ever lawfully tell you to agree to. You're totally in control of your situation until you walk into the courtroom and either come in front of the judge or come in front of the jury. And so I would really encourage you to do that. We did that specifically in family law cases, because in reality, family law cases, there may be about 2% law and 98% emotions. And we would always send anybody who wanted a temporary restraining order against the other side. We required them to go to mediation. And as a result, we rarely had any temporary restraining order hearings. And very often we would get presented an agreed decree of divorce, because the people were able to sit down in a calm setting and resolve their issues. That even happens with the biggest, corporations in the world. They realize that, I'm putting this into the hands of 12 people I don't know. I'm putting this into the hands of a judge I may not know. Let me go ahead and resolve it myself. And we even use it as I said earlier, on cases that come to us. We will occasionally send cases to mediation that we believe might have a chance of resolution, and very often do.
In my practice before I came to the court, I did a lot of estate litigation. And estate litigation has a slightly different kind of varnish than other cases, in that frequently in estate litigation, it's a win or lose everything. The will is valid or it's invalid. The testator breached their fiduciary duty, or the executor breached their fiduciary duty and is liable, or they're not. And so it's a kind of winner take all. In the car wreck cases or medical malpractice cases, you may win the issue of liability, but they may limit your damages. So there's some recovery, but not a lot. So in the cases that I was dealing with, primarily those estate litigation cases, we tried to point out to the lawyer, to the client, that is this settlement that we're talking about, this amount of money that you will get as a result of mediating your dispute with the other side, frequently siblings and other family members, is that amount of money enough to change the way you live? If it is, then maybe you need to think about taking this. If it's not, then we roll the dice. And that's not exactly mediation related in answer to your question, but it's sort of the conversation like the other judges were having with the parties in mediation. What is the factor that really motivates the underlying litigation, and what can we do to resolve it? And where's the tipping point? So, good question. Anybody else? Yes, sir.
I apologize in advance, I want to read it off my phone so that I get everything right. What are some measures you take in the process of making important decisions throughout any given case to be as free of bias as possible?
How to avoid bias in decision making. Steve.
There's really no good answer, I don't think. I reflect on the job I've been asked to do. I personally have encountered prayer for wisdom in making a decision. If I think at all that I might have a bias, I will step aside, what we call recuse ourselves. In fact, the first case we had this morning actually was a case that had come out of Matt's court, but tried after Matt was already on the Court of Appeals. But he'd signed some documents early on. The way I put it, our fingerprints were on the file, and he chose to recuse. That's a case of not letting your bias, get in the way. And I do the same thing. If I've got a case, I see 361st from Brazos County on it, and my fingerprints are anywhere on it, I'm gone. We'll have a visiting judge here. And I think over the years, what I want to do is I always focus on the fact that I want the people whom I serve to think that I have thoughtfully, carefully followed the law as it exists, not as I may want it to exist, and make the decision that I believe is based on the facts that have been presented to me. And that's about the best I can do.
Matt?
We go to continuing judicial education each year. So at one educational seminar, there was a lecture on bias. And I was in I'm 14 years in the criminal district court. And they really told you to be on guard because you can get jaded, because a lot of times all you see are people charged, I mean, obviously, all you see are people who are charged with a crime. And you hear stories and some of them start to sound the same. And you need to check yourself every once in a while, just to make sure that you're not becoming jaded and that you're giving everybody a fair day in court. So it's on our minds. It's a conscious thing. And if I ever felt like I wasn't giving someone fair shake or something like that, I'd get out of the way. There's plenty of, I'm had a retired judge, my predecessor who'd come in and sit for me anytime if I felt like, I heard too much like this at this point in time. It's something that you just have to be conscious of, and it's something we always kind of, just self-check.
I'll give a little personal story, and it has to do with recognition of bias. And first and foremost, well, let me give the story first and then I'll explain. Sitting around a dinner table, wife and daughter says, I've got a riddle for you. And if you've heard it, don't call out the answer. Let the other people struggle like I did. There's a terrible wreck out on the highway. And father and his son were seriously injured and taken to the emergency room. And the old doctor, the father was killed and the son is in the emergency room. And the old doctor walks into the emergency room and says, I can't operate on this child. This is my son. Who is the old doctor? And I went through all the usual stepfather, grandfather, godfather, God the Father. I went through all of it, trying to solve this riddle. And then I stopped and thought, what is it that keeps people from solving most riddles? And it's bias. It's you have a stereotype of someone. So is there anybody in the room that has not heard that riddle before? Okay, so a lot of y'all hadn't heard. Does anybody want to guess at who the old doctor is? That doesn't know the answer to the riddle definitively, but you have a guess of who you think it is. Yes.
Is the doctor the mother?
It's the mother. But the stereotype for most of us, especially of my generation, is old doctors are male. And so that is the stereotype, that's the bias that comes with my age, my gender, my training, my environment. The first key to making decisions without a bias is the recognition, not that you have the bias, but that you can be biased. Because if you recognize that possibility, you are more likely to note it when it does in fact exist. And that is what I do personally to try to avoid that situation of making a decision based upon a bias. When I see a fact pattern in a case that could affect me financially, it may not affect me financially, but it could be. I'm out. It's a way of insulating yourself from unknown biases. And that's the way that I approach it. So hope I answered your question. Anybody else? Good question. Even if you have to put it on your phone ahead of time and read it so that you make sure you get all the factors. That was a good idea. I didn't have that when I was growing up, you didn't have that computer in your pocket. And I can see our humanitarian dean wants to ask another question.
Yes, sir. Thank you. AI is a growing concern in higher education. On the one hand, it has tremendous possibilities and benefits. On the other, tremendous pitfalls and dangers, and it is fraught with both. My question, you explained to us earlier today, and provided answers about how you've seen cases change and the changes you've seen there. How do you see AI affecting what you do, affecting courts? And I'm really curious on both sides of that. Where do you see some benefits and advantages, and where do you see some drawbacks and some potential harm?
It is as big a gorilla in the room as you could possibly imagine. The concept of AI in its most fundamental approach in the legal profession is its use in writing briefs. We've already seen that on a national level, and we've seen it in our court. If you do a search on our court's opinions, you'll see the terminology, artificial intelligence in a footnote because of a brief that was filed that we have a very high confidence level that it was written by artificial intelligence and filed without being proofed or checked or anything else. But for me as a lawyer, and particularly as a judge, it goes to me much, much deeper for two reasons. We rely upon what we think we see. When you have the ability to alter that in what is commonly referred to, I guess, as deep fakes in photography or within documents, it's scary. We have traditionally relied upon a verification or validation of what a document is or a photograph is by someone who is familiar with it. And if you can authenticate a photograph by saying, yeah, this is real, this is the way it looked at the time, but yet have the ability to change that by artificial intelligence, or even more scary, create it. And not just a photograph, but an entire video of what has happened. The other part that scares me is the fact that we don't know what we don't know. It's almost like I'm getting back to the bias. It's what are we assuming about this document? It's that it was real. That's a real signature. And yet we don't know that it's not. And we may not have any witness that has direct connection to it because of the way you can authenticate, for example, government records. You don't even have to have a person that knows that it is authentic. It just came out of the government's file. And those two factors just scare me to death about artificial intelligence and its application in the law. And in virtually no case that is now tried to a jury is some aspect of social media, electronic surveillance, cameras in stores, that type thing, whether it's Walmart or the 7-Eleven or a business, all of it is videotaped. You have cameras everywhere. And then the ability to record and take a photo, everybody has it on their hip or on their purse or in their pocket. And so the reliance upon that type evidence and now the ability to modify it scare me as a lawyer and a judge.
What he said. And I'll also add that some judges, notably, I think the first one, Brantley Starr, Brantley is a fellow ACU alumnus of mine, and I know him. He had a local rule that said you have to certify that anything you're filing has not been created by AI. Now, will that help? Yeah, because we can get pretty much hammered by the Commission on Lawyer Discipline if we violate an order that we've been asked to follow. That is a start, but it's sort of like proverbial finger in the dike.
Man, I'll turn it over to you. We're running short on time, and so if you have a question, right after he gives his answer, we're gonna take the last question and then wrap up, please.
I'll be brief. One thing that I think is gives some resolve or some resolution to some of these things where evidence can be manufactured. There's a long history of being able to manufacture evidence, maybe not as well as AI can do it, but that's what trials are for. Trials test the evidence. That's their purpose. And if someone questions a photograph, don't think that a lawyer is gonna agree to some stuff. I mean, unless they're just not doing their job. You're gonna agree to something that they haven't already verified independently themselves. And so that gives me some resolve that it's not, going to turn us all in the wrong direction. Also, I think it's a useful tool. I do a lot of research on Westlaw, and there's a little box that pops up nowadays when I'm researching, and it says Westlaw has some suggestions for you. And I'll click that button, and every once in a while, that AI, it's an AI feature, finds a better case than I've been able to find with my search. So I think it's gonna be beneficial in some regards. I also think I agree, we have to be on guard, and we can't let it go too far.
I mean, it's out there because autofill when you're doing email, and if any of you have gotten one that you didn't actually intend to receive or sent one to somebody you didn't actually intend to send it to, as I am more likely to do, that's part of AI. I mean, that's the autofill feature is an AI feature, that we all have used. Okay. Anybody have that last burning question? Yes, sir. The Aggie hat.
My question for y'all is how much the results of last night's election affects y'all job like every day and then the next 4 years?
First state judges, that was a federal election.
Well, I mean, you've got state officers.
Well, the state officers, yeah, we're gonna have 3 new people on the Court of Criminal Appeal. No, all the Supreme Court justices get reelected. I haven't looked, Matt, you know?
Yes.
I think that, yes, they did.
Okay, so the Supreme Court will remain the same, except we're gonna have a new chief justice, because Justice Hector is aging out. And the governor will appoint somebody, which means the governor will then appoint a replacement for that seat. The legislature looks like it's gonna be about the same. They're the one that write the laws that we have to expound on. I don't see much of a difference there.
Well, last night's election, for me, because I was on the ballot.
I'm so sorry that you were unopposed.
I'm unopposed, but I'm on the ballot, and so it's an election, position chief justice. And so that's one thing.
None, 0. So, mostly because, as Steve said, the legislature that will have been elected they'll have to convene, write laws that may or may not get litigated for years. And so the direct and immediate impact is virtually 0. But in the long term, also as Steve mentioned earlier, if that legislature as convened writes a statute like continuous sexual assault of a young child, it can have potential enormous effect upon the nature of the cases that we see. But in the immediate future, it won't have an impact. So with that, we stand adjourned, and I know that the judges and some of the administration is convening for lunch, but we will see you back for the afternoon case at 1:30. Thank y'all very much.